somebody from Indonesia as well. So where's the rich one? She's not here. Perhaps she's upstairs. But does she know that the seminar is about to begin now? Probably, hopefully, probably. But anyway, she's not missing a lot so far. So, this is the first seminar that we have the PhD course in European law at the University of Ferrara, Rovigo campus. I welcome you all here. I'm very happy that you accepted my invitation from wherever you are, as I told you, and I'm more happier than that you also contributed, most of you contributed with the paper, with the presentation, with some notes, etc. But first of all, and most important of all, I'm grateful to Professor Fleming, who came here in this very small university, very small campus. He traveled a lot from his hometown and probably in the United States, and he came to Vienna for other seminars and other events, and then had the time to join us here in Italy. I'm very grateful to him for his time, for his support, for the paper, of course, for the presentation that is going, and we all appreciate it very much. Thank you very much for being here, and I would like also to extend my thankfulness to your wife as well. Is going to be with us this morning, listening to the presentation and this very lovely topic, isn't it? But as far as your husband is talking about, that topic should be lovely. and that's another one. Rules of engagement. Even if this event is part of the PhD course in Rovigo, Ferrara, and Bologna, I wanted the atmosphere to be as much informal as possible. As far as I know, there is only one native speaker in English, or two, because there is one. So I'm perfectly aware that most of you are afraid of language property. They are not sure whether they can have a conversation in English or they can express them in the most appropriate way when they are dealing with very technical topics like the one we are going to discuss about for the entire day. And as sometimes it happens, some of you could be somehow reluctant to give his or her feedback about the presentation, about PowerPoint or whatever, being afraid to not be in the position to speak properly in English. Please don't do that. The goal of this seminar, the purpose that we are trying to achieve, is to get as much feedback as possible. I'm pretty confident and I'm sure that any of you, starting from the undergraduate level up to the PhD and after PhD, LLM or whatever, can express them in quite a good English. And even if the English is not that good, even if you are speaking like me, for instance, well, in any case, I'm pretty sure we can understand you, make the most of every remark. So don't be afraid about the language, don't be afraid about your language skill. That's not important here today. That's not the point. And again, about the rules of engagement. We're going to have two presentations this morning, Professor Fleming one, and after his own presentation, my own, which will be very short, very limited. But we, at least I can speak for myself, but I think that even Professor Fleming shall agree on this. We accept remarks, comments, debate, discussion, whatever. And I speak also on your behalf at this point. So don't be afraid about it. We are very willing to hear your opinion on the topics that we are going to do. Rules of engagement. Problem. Two kinds of problems. We have, I was talking about this to play before, we have Yes, it's welcome. Welcome, Anthony Morano and Andrea Greggi. Take a seat wherever you want, I just started.
Sì, no, vabbè, basta dirlo.
Well, now we're the other topic that I was focusing about, let's call it no rules of engagement for the day. I mean, the atmosphere is very informal, and so we try to be as much flexible as possible. Accept comments, remarks, feedback from the audience, and whatever. We are going to have other two problems today, that the legal background of the people in this group is remarkable. Some of them are students from the undergraduate course in international taxation. Some of them are so-called Erasmus with a really good legal background in Italian law, in Italian taxation. Some of them are Erasmus students. These students coming from another European country to spend some time here doing their international tax law course and whatever. So they got a good background in Spanish taxation law, for instance, or whatever. But not that good. Okay. Some other students are from the LLM course in the University of Bologna, so they got their degrees, their degree, and I got to take a picture of this room. You can see the room feel like this one. Well, I was saying about some of them are LLM course in taxation law after the jurisdoctor degree. Some other are PhD students, first, second, or third year advanced students. Others of them, like since the degree now got their PhD, and so after still research in taxation and in international taxation law. While others are coming from or participating from the European law course. So it's PhD, we got PhD, or they are doing research in that, but they are not specific background in taxation. So we can enjoy or make the most of this diversity, getting the feedback from people who are not expert in taxation, but can provide a different perspective on the topic that we are going to talk about on these days. And now, in religions, all the continents are forward. This is the last point, then I'll stop my very brief presentation. The last point, but I'm afraid is going to take some time, a few minutes, but we have to do that since there are a lot of people here. I would like to ask you all to introduce yourself, standing on feet if possible. If you will take a seat, that's great. Telling us your name, surname, and why you are here. What is your exact position? Starting from the left and going on this direction, and from the front to the back, telling, for instance, I will begin saying that I am Marco Greggi. I am a professor of taxation law in Ferrara and in Rovigo, and I'm here because I organized this. You all know Professor Philip Fleming, because you got his presentation on the net. It's from the United States, from Utah State. Spent some time in Sao Paulo, perhaps, I don't know, in Vienna, and if you want to add something more, perhaps on your experience there, you can go on with the students, starting from there and then to the right. It's just one. The reason for it is that there are some people of you that I don't know. It's going to be a good occasion for me. Myself.
My name is Leonardo Silvestri, and doing the PhD in Bologna University in tax.
I'm Giuseppe Bulgarelli. I'm PhD from the University of Bologna and LLM at the Brunel College, University of London.
I am Laura Salvi. I am a Ph.D. student in European Law at the University of Ferrara.
I am Gianluca Barella, a student at the University of Bologna.
My name is Marco Greggi. I'm from Indonesia. I'm a student at the University of Ferrara, and I'm working for the Ministry of Good morning, I'm a student here in the Faculty of Law.
Hi, I'm Marco. I'm a student in Ferrara and following the international taxation course with Professor Greggi.
Second row, please.
I am Rovigo, and I am a Ph.D. student in European Law in Ferrara and Rovigo.
I'm Rovigo, and I'm a Ph.D. student of European Law in Rovigo.
I'm Margherita, I'm a Ph.D. student of second year in the University of Ferrara and European Law.
I'm a Stefano Buono, and I am a student of European Law.
Hi, my name is Cesare Roberto. I'm a Ph.D. in European Law.
My name is Paolo Baravino, with the University of Bologna, Scuola Europea di Dirittotributario.
Hello, my name is Francesco Vella. I'm assistant professor Maisto in Piacenza, University of Piacenza. I'm a tax consultant and LLM in University of Vienna.
Hi, I'm Claudia Ringiati. I'm one of the students of the University of Piacenza.
My name is Rovigo. I am a PhD doctor at the University of Bologna in European Law.
My name is Teresa Ortiz Rosa, and I study at the University of Ferrara, and I am a student Erasmus from Spain.
I am Eva Mazen. I study My name is Cristina Marco, and I study in the University of Ferrara, and I am Erasmus from Spain.
I am Rovigo. I am a student Erasmus of the Faculty of Law.
Hi, I'm Stefano. I'm a student of Rovigo.
Hi, I'm Silvia Andriotto. I'm a student of Rovigo University, and I'm here for improve my knowledge in tax law.
My name is Wen Yang. I come from China. I'm a PhD student in the European tax law at the University of Bologna.
Fernando Labella, European Tax Law Bologna, doctorate, and also Ministry of Finance Brazil.
Hi, my name is Tika Bellendi. I'm from Bologna. I'm doing the doctorate in European tax law.
I'm Tony Bonanno. I'm actually a student doing a master's degree at Johns Hopkins University. I've just retired. I was an U.S. international tax lawyer for 35 years.
I'm Andrea Carici. I'm a tax law professor at the University of Bologna, Faculty of Law. Nice to meet you. I'm here just because Mark is a colleague of mine and invited me, and so I'm pleased to be here.
My name is Cristiano Bottazzi. I'm a Ph.D. student at the University of Bologna.
My name is Federico Antoci. I am a PhD candidate at the University of Bologna in European tax law.
Hi, my name is Davide De Giorgi, and I'm a PhD in the European tax law to the University of Bologna.
My name is Lorenza Marigo, and I am PhD student European Law, University of Ferrara.
My name is Jacopo, and I am a PhD student in Bologna.
So my name is Stefano Martinengo, and I'm a PhD student at the European Tax Law at the University of Bologna.
Hello, I'm Lucia Danici. I'm a PhD student in European tax law I am a Ph.D. student of European Tax Law, University of Bologna.
My name is José Miguel Martín from Spain. I'm also a PhD student of European Tax Law at the University of Bologna.
My name is Rovigo. I'm also a PhD at the University of Bologna.
Hi, I'm David Villa, and I'm a student of University Catholic in Piacenza.
Now, all presentations are done. The presentation is over, so I see at least to introduce yourself, you got 5 seconds, but I just promise me from all of you, I don't want these to be your last words in this class. I expect from all of you maybe a short remarks or comment or whatever at the end of this day about what are going to be your impression on this sentence. That's it. Okay, now I think we are still scheduled for this morning, and I can leave the floor to Professor Fleming to introduce the topic. We're going to talk about for the entire day, late morning and early afternoon.
Very good. And I repeat Professor Greggi's invitation to you to put up your hand and ask questions if at any point you do not understand what I'm saying. I studied a related language 60 years ago. 60 years ago, when I was a high school student, I studied Latin, but abandoned it because there was no one that I could have a conversation with. That was the only time I have ever studied any language that has any relationship to Italian. I know ciao, and that's about it. So I'm trapped within an English vocabulary, and I will do the best I can to speak clearly. But if at any point you do not understand what I'm saying, do not be in the least embarrassed to ask for clarification. Now, because many of you have only a limited exposure to international taxation, it may be useful for me to take just a few minutes and describe the context in which the technical problem that we will be dealing with today arises. And I can, I think, begin illustrating the context by telling you that the government of the United States spends more money every year than any country in the world. The government of the United States every year spends about 2 trillion euros. That is an enormous amount of money. Various studies have been done investigating how long it would take a human being to spend 2 trillion euros if he was spending the money as fast as he could, buying a new Mercedes every 5 minutes, buying a new house every 5 minutes, so on and on. It would take an ordinary human being several lifetimes to spend $2 trillion, which is the amount that the United States government spends every year. Now, the reason that fact is relevant is because every day in the world, more than $2 trillion of money crosses international borders. The movement of money every day in the world across international borders is greater than the enormous amount of money that the United States government spends every year. And much of that greater than $2 trillion a day movement of money across international borders represents profits of various kinds that have been earned on investments or in business transactions. The nations of the world see that as a gold mine. They see that enormous movement of international profits across borders as an opportunity for them to tax and secure revenue to provide for the national defense, education, national health, and so forth. The nations of the world have developed a body of customary international law that in a very broad way defines their rights to divide up this flow of profits across international borders, and each country claim a share of those profits that it can tax. And the basic rules that have been developed by customary international law are, first, that the residence country, the country where the earner of the profit or the income is resident, has the right under customary international law to tax its residents on their worldwide incomes, on profit that they earn regardless of whether it was earned within the borders of the residence country or in some other country. The second rule of customary international law is that every country in the world has the right to tax profits or income earned within its borders, regardless of whether that profit or income was earned by a resident or by a foreigner. Now, this obviously creates the reality of double taxation of international income, because the resident country is insisting on the right to tax its residents on income earned abroad, and the foreign country is insisting on the right to tax that income because it was earned within their own borders. And customary international law has developed ways in which the two countries are supposed to adjust this conflict. The basic rule of customary international law is that the country where the income was earned, which we refer to as the source country, gets to go first, or as we say in the United States, gets the first bite of the apple. And it is the responsibility of the residence country to take steps to make adjustments to accommodate the source country's taxing right so that double taxation does not occur. One of the ways in which the adjustments are made between the residence country and the source country is that they enter into bilateral income tax treaties. There is only one multilateral income tax treaty that I'm aware of. It's the so-called Nordic Treaty among the countries of Scandinavia and Iceland. But otherwise, all of the income tax treaties on planet Earth are bilateral treaties. And they involve representatives of a pair of countries sitting down and negotiating rules as to how the tax systems of the two countries will be coordinated with each other in order to avoid double taxation of the residents of the two countries. These bilateral income tax treaties generally make the necessary adjustments to avoid double taxation by each of the countries agreeing to give up some of their customary international law taxing rights against income earned by residents of the other country. For instance, it is extremely common in the bilateral income tax treaties for the source country, the country where the income is earned, to agree agree to reduce the tax that it imposes on interest, dividends, royalties, to reduce the tax that it imposes on income, that kind of income earned within its borders by residents of the other country. And of course, the reciprocal principle applies. The resident of the first country agrees to reduce its tax on residents of the second country. That creates the problem of treaty shopping because country A and country B may agree on a treaty and agree to each reduce the taxes that it imposes on income earned within its borders by residents of the other country. And residents of country C look at those tax reductions and they say, that's very attractive. I would like to take advantage of the tax reduction that country A has made on behalf of the residents of country B. Unfortunately, I'm a resident of country C, and my country doesn't have a treaty with either country A or country B. What shall I do? Well, the answer is I shall disguise myself as a resident of either country A or country B. I will not do it in a criminal fashion. I will find some legal way to disguise myself as a resident of country A or country B. And in other words, I will engage in treaty shopping. I will look around the world and I will say, oh, the AB treaty, that's very attractive. So I will turn myself into a resident of country A or country B so I can take advantage of the favorable tax reductions that are contained in the country A or country B treaties. Well, for many years, the United States has regarded treaty shopping as a significant abuse of its bilateral income tax treaty network. And consequently, as Europe becomes more concerned about treaty shopping and about imposing restrictive measures on treaty shopping, it may be useful for Europeans to examine the American experience for methods that work and for mistakes that Americans have made that Europeans can avoid. I'm going to make 3 basic points about the American experience with treaty shopping and so-called limitation on benefits clauses. The first point is that the U.S. measures that have been adopted to restrict treaty shopping in the form of limitation on benefits clauses that are included in all bilateral treaties entered into by the United, all bilateral income tax treaties entered into between the United States and its treaty partners. The U.S. measures began with very simple steps that have grown into a limitation on benefits treaty article that is amazingly complex. It is mind-numbingly complex. Second point, the objectives of this extremely complex treaty article and the policies behind it are not clear, and they're to some extent confused. And so any European country contemplating developing a limitation on benefits clause should think very clearly about what its objectives are. What is it that it's trying to accomplish? Third point, in spite of the complexity of the U.S. limitation on benefits treaty article, the article has a significant loophole that substantially reduces its effectiveness. So the article that the United States insists on including in all of its bilateral income tax treaties, it is very complex, goes on at some length, is very difficult to read. But when you get to the end of it, you find that it has a large loophole that allows a good deal of treaty shopping to continue to occur. The U.S. complaint against treaty shopping is usually explained in the following way. A bilateral income tax treaty is a contract under which each partner state gives a taxing right. Am I supposed to stop? Oh, sorry. A bilateral income tax treaty is a contract under which each partner state gives up taxing rights against against residents of the other state in order to secure benefits for its own residents. And indeed, to stimulate treaty negotiations, the United States Internal Revenue Code imposes a very high withholding tax on the gross amount of U.S.-sourced income and the nature of dividends, interest, and royalties paid out of the United States to residents of other countries. It's a tax of 30% on the gross amount of dividends, interest, or royalties. But then the United States government follows a policy of consenting to significant reductions in that very high rate of income tax withholding. The U.S. follows a policy of consenting to significant reductions of that tax rate in its bilateral negotiations with its treaty partners. The idea behind this policy is that if the United States starts from 30%, it creates an incentive for all of its trading partners to come forward and enter into negotiations to get that 30% rate reduced for the benefit of their residents. And secondly, it puts the United States in a very strong position to begin the negotiations. But the United States has bilateral income tax treaties with only about 60 of the more than 190 countries that are members of the United Nations. Some countries are not interested in having a bilateral income tax treaty with the United States because some countries are substantial net importers of capital from the United States, and therefore they do not wish to reduce make reciprocal reductions of their withholding taxes on income earned within their borders by United States investors and by United States businesses. So the United States has no bilateral treaties by and large with those kinds of countries. Other countries unilaterally impose a zero or a very low rate of tax on foreign investors and foreign businesses that come within their borders. And so in that situation, there is no need for the United States to negotiate a treaty with that kind of country. It is, if you will, already unilaterally disarmed. It has already unilaterally made all the concessions that the United States would want to bargain for in the first place. And so the United States does not enter into bilateral income tax treaties with that kind of country. Finally, some countries attract so little attention because they have very small markets or they're very remote in their location. Some countries attract so little attention from U.S. businesses and investors that it is not efficient for the United States government to incur the costs of negotiating bilateral income tax treaties with them. For all those reasons, the United States government's bilateral income tax treaty network involves less than 1/3 of the countries of the world. This means that many individuals who would wish to invest in the United States and many companies that would like to sell goods or services into the United States market do not officially have access to the benefits of a bilateral treaty between their country of residence and the United States. Many of these individuals and businesses who are resident in countries that do not have bilateral treaties with the United States refuse to passively accept their fate. And as I said a few moments ago, instead they seek to transform themselves into beneficiaries of treaties between low-tax countries and the United States. They choose a low-tax country, and in the example that I gave you in the materials that Professor Greggi distributed to you, I chose Ireland because the Republic of Ireland is a low-tax country. These residents of countries that are not treaty partners of the United States choose a low-tax country so that the tax they have to pay there can be considered a reasonable cost for the benefits of access to a treaty with the United States. The United States objects to this maneuver of residents of non-treaty countries dressing themselves up like residents of treaty countries, because if it is successful, non-treaty country residents then get treaty benefits without their home countries having made any reciprocal concessions for the benefit of U.S. residents. To put it another way, if the treaty shopping strategy succeeds, then non-residents of treaty countries are able to convert a bilateral treaty, which was negotiated to create a very carefully crafted balancing of interests between the United States and another country. The residents who successfully treaty shop are able to turn that bilateral treaty into a treaty with the world, under which residents of countries that have not made concessions for the benefit of U.S. residents are able to come in and claim benefits under the treaty, even though their home countries haven't paid for those benefits by making concessions in behalf of U.S. residents. In addition, if residents of non-treaty countries can readily transform themselves into beneficiaries of U.S. tax treaties, then the non-treaty countries have no incentive to enter into treaty negotiations with the United States, and some treaty countries may even terminate their treaties with the United States. They may even look it over and say, well, our people can go to the country C or country D treaty and get everything we need there. We'll terminate our treaty with the United States. Well, what I have described to you is the essence of the treaty shopping problem from the viewpoint of the United States Treasury. The story of the U.S. response to treaty shopping is long and complicated and can best be illustrated by framing our discussion in terms of the example and the literature materials. And let's go through that. We start with a hypothetical individual. Adnan Aziz, a resident of Petroland, an oil-producing country that has no income tax and no bilateral income tax treaty with the United States. Mr. Aziz wishes to manufacture high-quality glassware and sell it into the United States. To do so, he might set up the following structure. I know some of you have looked at this, but it may be helpful if I put it on the board again. He's a resident of Petroland, and there's lots of sand in Petroland, and there is cheap energy there to fire the furnaces to melt the sand and turn it into glass. And so something that he might think of doing is a structure that looks like this. He would form Petroco, a company formed under the laws of Petroland and therefore a resident of Petroland. He would form, in a very common structure, USCO, a United States company that is wholly owned by Petroco. So Petroco is the mother company and USCO is the U.S. subsidiary. Petroco would then sell glassware that it manufactures in Petroland to USCO. USCO would then sell the glassware onward to U.S. consumers. And of course, there are profits on on the sale by U.S. code to the U.S. consumers. And so the U.S. profits tax would apply to those profits. And there's really no way to avoid that. Regrettably, for Mr. Aziz, who owns all the stock of Petroco and is sitting at the top of the structure, regrettably, the U.S. profits tax can go as high as 35%. There's really no way to avoid that if he's going to set up his factory or set up his selling organization in the United States. Now, with respect to profits on the sale of glassware to U.S. code, profits on sale by the mother company to the U.S. subsidiary, assuming that Mr. Aziz has been properly advised, there will be no U.S. tax on those profits. Assuming Mr. Aziz has been properly advised, the sales from Petroco to U.S. Co. are structured so that the sales are considered to take place in Petroland, Mr. Aziz's country of residence, where there is no income tax. And all Petroco does is make delivery to U.S. Co. And in that situation, it's clear that no U.S. tax applies to those profits. Where the U.S. does take its tax bite is on dividends that are paid by U.S. code to Petroco's mother company. And there, since there is no treaty between Petroland and the United States would withhold 30% of the gross amount of those dividends. Pretty substantial bite to take out of the apple. All right, that's what's going to happen to Mr. Aziz if he just acts like a sheep and does the natural sort of thing. But if Mr. Aziz and his advisors have even the least bit of imagination, they're not going to allow this to happen. Instead, what's going to happen, is this the eraser? Okay.
Worse.
Yeah, not bad now. An eraser. No, it's the technological cutting edge. Okay. Instead, what Mr. Aziz is going to do is he's going to set up an Irish company that we'll call IRCO. He's going to form a company under Irish law in County Waterford, Ireland, where they make Waterford crystal. And that's where he's going to put his glass manufacturing facility, in the Republic of Ireland. And he's going to own 100% of the stock. I'll write his name there because he will become an important player in the story as we go along. All right, now instead of having the glassware manufactured in Petroland, we're going to have the glassware manufactured in County Waterford, Ireland. IRCO is going to sell the glassware to U.S. Co., the U.S. sales subsidiary, except now IRCO is the mother company, and U.S. Co. is the U.S. subsidiary of the Irish mother company. Again, assuming that Aziz has been properly advised, there is no U.S. tax on the profits generated by the sale from IRCO to U.S. Co. There is U.S. profits tax on the sales onward by U.S. Co. to the U.S. consumers, and it's at the rate that goes as high as 35% if U.S. Co. is really very profitable. But the big change here is that there is a treaty between the Republic of Ireland and the United States. And that treaty reduces the withholding tax on the dividends from 30% to 5%. a 25 percentage point reduction. Very attractive. Very good. Excuse me, I brought a cold with me from Vienna, and so I may struggle at a moment now and then with my voice. The Republic of Ireland is going to charge a tax on all the income that is received by IRCO, on the profits that it earns on its sales of glassware to USCO, and on the dividends that USCO pays home to IRCO in the Irish Republic. But that's a fairly low rate of tax, 12.5%. Moreover, Mr. Aziz and his advisors are going to make certain that there really isn't very much income here for the Republic of Ireland to tax, because Mr. Aziz, who is a brilliant businessman and who knows a great deal about business strategy, is going to enter into a consulting contract with IRCO, under which IRCO is going to pay him consulting fees for giving it lots of valuable advice about how to conduct its business. Now, Mr. Aziz, of course, isn't going to come to Ireland. He's going to render all of his advice by email, by telephone, by fax, from his home in Petroland, which means that the Republic of Ireland is going to look at this and conclude that these fees are not Irish source income. They're actually being earned where the work is done in Petroland, so there isn't going to be any tax on these fees that are paid to Aziz, but they are going to be treated as a deductible business cost by IRCO for purposes of calculating the amount of profit to which the 12.5% Irish tax applies. And we're going to siphon off as much of that profit as we can in the form of deductible consulting fees to Mr. Aziz. The only limitation on that strategy will be Irish transfer pricing law. And here I guess many of you don't know what transfer pricing law is. Transfer pricing law in the world says, no, you can't do this. You can't just pay Aziz exorbitant amounts of money for doing very little work. Instead, you can pay him only the amount that he would earn if he were rendering those same consulting services to an independent company that would pay him only what he's worth. That's how transfer pricing works. Except that the Republic of Ireland is widely understood not to have any generally enforced transfer pricing rules, so that we're going to be able to pay quite a lot of IRCO's profits from IRCO to Mr. Aziz, so that yes, a 12.5% Irish tax will apply here, but it won't apply to very much. We move most of it to Petroland, which doesn't have an income tax. All right, well, that's what Aziz is going to do if he and his advisors have any imagination. They're not going to just lie there and let Mr. Aziz get kicked to the extent of a 30% withholding tax by the United States government. Now, there are debates in the literature. I just want to make sure I've covered all the points that I had in my outline. There are debates in the literature about whether particular cases involve treaty shopping or merely examples of creative tax planning. I don't want to deal with that topic because the assignment that Professor Greggi gave me is to focus on how U.S. treaty policy deals with treaty shopping. So let's assume that there are no non-tax factors that drove Mr. Aziz to set up his structure, that he did not locate his production facility in Ireland because of labor costs, because of infrastructure concerns, because of proximity to markets. Let's assume that Mr. Aziz has set up his structure solely for the purpose of getting the benefit of the reduction in the U.S. withholding tax under the U.S.-Ireland Treaty from 30% down to 5%. In other words, let's assume that the only reason Mr. Aziz has set up this structure that I've diagrammed for you on the board is that he is engaged in open and brazen treaty shopping. If he gets away with it, he will have secured treaty benefits that his residence country did not pay for in the form of concessions made for the benefit of U.S. residents. And his country, Petroland, will have a reduced incentive to ever enter into a bilateral treaty with the United States because they will see that Aziz and all the other residents simply have to go to Ireland and set up shop there and get full treaty benefits. Why enter into a treaty with the United States? Consequently, Mr. Aziz's scenario that I've described to you seems to present exactly the kind of case that triggers the long-standing U.S. concerns regarding treaty shopping. Historically, the first line of defense in U.S. treaties against treaty shopping was the rule that only residents of the two treaty partner countries can qualify for treaty benefits, including this 25 percentage point reduction in withholding tax. Now, although Mr. Aziz is obviously the ultimate economic beneficiary of the dividends that are paid by USCO to IRCO, although Mr. Aziz is sitting at the top of the food chain here and is ultimately the economic beneficiary, Article 10.2 of the treaty, which again was in the materials that Professor Greggi distributed to you, incorporates language that refers to dividends, quote, paid to a resident of the other contracting state. In other words, under the treaty, we don't look to who is the ultimate economic beneficiary. We look to whom were the dividends paid by USCO. When we look at that, we find the dividends are paid to IRCO, even though Aziz is the ultimate economic beneficiary of them. And so we focus on the question of, is IRCO a resident of Ireland or the United States, and therefore a resident of one of the two treaty countries who's qualified for treaty benefits? Well, obviously, IRCO is not a resident of the United States on the facts that I described for you here. But under 4.1 of the treaty materials that Professor Greggi distributed, IRCO is indeed an Irish resident for treaty purposes because IRCO is subject to Irish income tax on account of the fact that it was incorporated under Irish law. Thus, the residence requirement that one can benefit from this 25 percentage point reduction in the 30% U.S. withholding requirement, only if one is a resident of either the U.S. or Ireland. The residence requirement is no barrier, because Aziz has arranged under this structure for USCO's dividends to be paid to an entity that technically qualifies as a resident of Ireland. Now, the Western European countries that have played a major role in shaping the OECD model income tax treaty, which some of you are familiar with, others of you who are doing general European law are totally unfamiliar with it. But the story briefly is the old League of Nations that collapsed after the Second World War began a project in the 1920s of developing a model bilateral income tax treaty that would be entered into by all the important commercial nations of the world. And in the aftermath of the Second World War, that project was passed on to the Organization for Economic Cooperation and Development, headquartered in Paris. And the OECD has developed this model income tax treaty that is used as the basis for bilateral income tax treaty negotiations of all the countries in the world. And if you look at the bilateral income tax treaty between Kazakhstan and Azerbaijan, you will find that it bears a remarkable resemblance to the OECD model treaty that was developed in Paris by the OECD. Well, the Western European countries have played a major role in shaping OECD treaty policy, and those Western European countries have historically been considerably less concerned than the United States about treaty shopping. And so the first steps taken by the OECD to address the treaty shopping issue were quite modest. Specifically in 1977, 10.2 of the OECD model was amended to provide that a party receiving a dividend would not be eligible for a withholding tax rate reduction provided by a treaty unless the party receiving that dividend was both a resident of one of the treaty countries and temporarily in a brain freeze, and was a beneficial owner of the dividend. So after 1977, there were now two requirements that Mr. Aziz would have to satisfy. Not only would IRCO have to be a resident of Ireland, but it would also have to be beneficial owner of the dividends paid by U.S. Code IRCO. Well, does IRCO qualify as beneficial owner in light of the fact that most of its income, including the dividends from U.S. Co., will be paid onward to Aziz, mostly as consulting fees, but perhaps some small portion will be paid onward to Aziz as dividends from IRCO to Mr. Aziz. Neither the OECD model nor the U.S. model income tax treaty, which was distributed to you by Professor Greggi, neither of those gives a precise definition of the term beneficial ownership. And the case law interpreting the phrase beneficial ownership in the various treaties has also failed to provide a full, comprehensive definition of the term beneficial ownership. However, if we engage in some reasonable assumptions, if we assume that IRCO's cash flow is not automatically pushed through to Aziz as it is received as dividends from U.S. Co., if we assume instead that Aziz must actually render substantial consulting services and that he's not entitled to be paid until he performs those services and sends a bill, or is that what they say in Italy, a statement, sends a bill or a statement to IRCO for services actually rendered. And if we assume that Mr. Aziz is only a general creditor of IRCO, that is, he has no preferential right to be paid for his services over other suppliers to IRCO, and if we assume that IRCO has some degree of discretion as to when it will pay the bills that Mr. Aziz submits for his services, and if we assume that IRCO does earn a small profit at least after paying Mr. Aziz's charges for consulting services, if we assume all that, then it seems pretty clear that IRCO is not receiving dividends as a mere nominee, agent, or fiduciary acting for Mr. Aziz. And in that situation, the case law indicates that IRCO will be treated as the beneficial owner of the dividends it receives from the U.S. Co. So, if the only anti-treaty shopping provisions in the U.S.-Ireland Treaty were the residence requirement and the beneficial owner requirement, then Mr. Aziz's plan would work. But of course, the treaty contains a final line of defense against Mr. Aziz's strategy, the comprehensive limitation on benefits provision found in Article 22 of the U.S. model that Professor Greggi distributed to you. The Western European countries that played a major role in the OECD were for many years quite skeptical about the correctness of U.S. concerns regarding treaty shopping. The Western European countries find that times have changed. They've become more interested in the treaty shopping problem, and indeed the commentary on OECD Model Article 1 now includes a suggested comprehensive LOB clause that closely follows Article 22 of the U.S. model. But for whatever reasons, the historic pattern was that the U.S. was extremely concerned about treaty shopping. The rest of the world was less concerned. And so the development of comprehensive LOB clauses was primarily a U.S. activity. I'm running out of time. Yes. The U.S. LOB treaty erects a new line of defense. Now, to receive the benefit of the 25 percentage point reduction in the rate of tax on dividends paid by U.S. Co. to IRCO, not only must IRCO be a resident of Ireland, not only must IRCO be the beneficial owner of the dividends, but IRCO must be something called a qualified person. A new layer of defense has been added by the U.S. treaties. IRCO must be a qualified person. Article 22.3 of the treaty lays out several incredibly complex tests for becoming a qualified person. And if you work through those, you would readily see that IRCO doesn't satisfy any of those tests. IRCO cannot be a qualified person under the treaty. But then, in 22.4, the United States LOB article gives it all away. It provides that if IRCO is conducting an active business in Ireland, which it clearly is, what could be more active than shoveling sand into furnaces as Irishmen who do the shoveling are sweating, and then heating up those furnaces with gas and spitting out molten glass? Nothing could be more active than that. So IRCO is carrying on an active business in the Republic of Ireland. And Article 22.4 goes on to say that if the dividends that U.S. Co. then pays to IRCO are incidental to or connected with IRCO's active manufacturing business, and they are, because they are generated by U.S. Co.'s sales of the stuff that IRCO is making in Ireland. If it were not for IRCO's active manufacturing operation in Ireland, there wouldn't be any dividends. So, I could take you through some technical language in the treaty, but I'm running out of time, and Professor Greggi has a lot that he wants to say. So just trust me. 22.4 says, therefore these dividends are related to and incidental to the active business that IRCO is carrying on in Ireland. And what is the result of that? The result of that is we don't care that Aziz is engaging in treaty shopping. We say, Mr. Aziz, it worked. Because you're carrying on an active business, and the dividends you're receiving are the fruits of that active business, then your strategy works. You get the benefit of the 25 percentage point reduction. Now, one is left to say, why in the world did the United States arrive at that position? Is it because they don't think Aziz is engaged in treaty shopping? If so, the Treasury Department officers have lost their minds because he is clearly engaged in treaty shopping. Is it because they don't believe it's a problem? Well, he's getting the 25 percentage point reduction without his home country having made any concessions to the United States to pay for that 25 percentage point reduction. And that is supposed to be the classic concern that drives the United States with respect to treaty shopping. So one is left utterly without explanation as to why the United States government has given it all away to Mr. Aziz because he's carrying on an active business. And in conclusion, I will say, if you look through the LOB material, treaty materials that Professor Greggi has distributed to you, and that I have mercifully spared you from going through point by point, the LOB article that the U.S. has developed for restricting treaty shopping is extraordinarily complex. The objectives and policies behind that LOB article are not clear. Why in the world do we have all this language and at the end of the day give away the store to Mr. Aziz? In spite of the clause's complexity, it contains this huge loophole which allows Mr. Aziz to freely treaty shop as long as he's willing to do it by setting up an active business in a treaty partner country. As Europeans move into the world of LOB clauses, I hope that they can use the U.S. experience to do better than the U.S. has. And now it's you.
Thank you very much. Thank you very much for your presentation, the lecture, and the ideas you gave us to develop our research for the future. So, questions, comments, remarks, particularly coming from those of you who don't have a textual background and perhaps find something strange or new, or perhaps some topics of Professor Flem's presentation touching some aspects of their field that have something in common with concession law. The idea of the limited advantages attributed to one country or to another country using a treaty not involving taxes but perhaps commercial privileges or sell goods or assets from one country to the other. Yes?
Yes, I have a question. This is related to the joint venture agreement. In my country, there is an investment law, and this investment law obliges the foreign investment who wants to, for FDI, for their investment like Freeport in Indonesia, they have to establish the new company under the Indonesian law. And this company is consists of two shareholders. One is the foreigner and one is the Indonesian one. Mm-hmm. And sometimes the other foreign citizens, they also engage in this kind of company. Not only from the United States, maybe from one company there will be from Japan, China, and from other countries. And since I'm not studying tax law, I'm not studying tax law very intense, so I didn't notice about this kind of thing that the third person from the third country who not engaged in the bilateral treaty, they may take and benefit from this kind of treaty. My question is the joint venture agreement can be the entrance point to take the benefit from this kind of limitation of benefit.
You mean, yeah, you need to incorporate a sort of joint venture, to just like acting like sort of Trojan horse.
The effort to be a special vehicle to do this kind of.
The problem does not come up under U.S. law because there is no requirement under U.S. trade law or investment law that the U.S. code be owned by, to any extent, by U.S. residents. Under U.S. law, it is perfectly acceptable for a U.S. code to be entirely foreign owned. And so we simply don't have the problem of our code being forced to take in a joint venture from the United States. If that would be a free choice on the part of our code. If our code did decide to have U.S. code issue some of its stock, some of its shares to Americans, then the treaty shopping issue that we have been discussing would apply only to the dividends that are paid by U.S. code to our code. The dividends paid by U.S. code to Americans would simply be outside the scope of this discussion. They would clearly be within the taxing jurisdiction of the United States and subject to the normal rates that the United States charges its own residents on their income.
If I see from this kind of scheme, from the dividend itself, it is related to the most favored nation clause in the Ph.D. bilateral investment treaty also. I think there is but besides there is a basic treaty in the most favored nation. There is another treaty that others that they can engage in the Iranian oil cases. They can engage in this kind of treaty. They can take this kind of treaty. And he said that in this kind of treaty there is a reciprocity rights and I think based on the FMN's unconditional FMN is allowable for the third party to take the benefit from this kind of treaty.
Well, of course, that would require the third party's country to have entered into its own treaty with the United States. The United States does have a few bilateral treaties, a very small number of them, that contain most favored nation clauses. My memory is the U.S.-Mexico treaty has one, and maybe the U.S.-UK, I can't remember, but the U.S.-Mexico treaty has one. So there's a very small number of U.S. bilateral income tax treaties that have most favored nation clauses. 95% of them don't. But if it were the case that there was a treaty between Mr. Aziz's home country, Petroleum, and the United States that had a most favored nations clause in it, then Mr. Aziz would be able to set up a structure that allowed his company to take advantage of the 25% point reduction provided in the Ireland treaty. But that is, in the world, it's interesting, there are a number of distinctions between income tax treaties and trade treaties and investment treaties. And one of them is that most favored nation clauses are quite unusual in income tax treaties.
In the Chinese experience. I stumbled into most favored nation clause in the treaty with Kazakhstan. There we have most favored nation clause concerning interest, or here the Dutch member actually. The third initial withholding tax was at 15% or 10%, and now dropped to 3% because Kazakhstan negotiated.
This is an Italian tax treaty?
Yeah, it's an Italian.
In the U.S.,
very common.
Yeah. In the U.S., FCN treaties are usually not from the Treasury.
That's another
It's a
difference.
totally different thing.
They're totally different. In the U.S., different branches of government and different parts of the Congress deal with the treaties, so that commercial treaties go down one track and income tax treaties go down another track, and you get very different results.
So you said that in 1977 the beneficial ownership concept was implemented in the OECD Convention. Was it because of the United States activity on that, or
Yeah.
it was completely different?
Yeah, the United States has nagged the Western European countries for years and years, and it's generally understood that the beneficial ownership provision was inserted in 1977 to deal with treaty shopping, largely because the United States nagged the other countries long enough.
That's it. Any other questions, comments, or?
First of all, I'd like to point that in Brazil and USA don't have actually a little
It's
a
Brazil is.
It's a trade treaty.
Brazil is one of the U.S.'s largest trading partners,
Yeah.
but it doesn't have a treaty with the U.S. So it's quite unusual.
Yeah. In fact, I would say that the Brazilian and USA officers play sort of hard game.
Yeah. With each other.
I know they are my colleagues. I know all. Yeah, but I'm a little bit concerned about the benefit owner. How could the USA administration, for example, in this case, control the situation if USA decided to disqualify a company? Because the auditing would be placed in Ireland, not in the USA.
It's for measures, how you get the evidence about the fact that the company is not the official owner, or
to make it
discussion.
To make it effective.
Yeah.
I guess that's a little bit difficult. There are some sensible issues beside this.
Article 25 provides for the exchange of tax information between the party countries. So the United States would submit a request to the Tax Administration of Ireland to provide information.
Yeah, but in specific cases, when they have a slight idea of what's happening, this is not something about each and every trade company, I guess.
Yeah, I mean, you're quite right to suggest that in the ordinary course, the United States government would not know the terms of the agreement, of the consulting agreement between IRCO and Mr. Aziz, and would not know whether Mr. Aziz is actually doing the work for which he's being paid, or whether IRCO is simply acting as a fiduciary or an agent to gather money and pass it onward to Mr. The Irish tax administration would have an interest in this, of course, because the payments to Mr. Aziz are deductible business expenses only if he's being paid for work. If IRCO isn't paying him for real work, then the Irish tax administration would want to not allow a deduction for the amounts paid to Aziz. So the Irish tax administration may have its own interests to look into this and gather information that it could share with the United States. But of course, at this point, information sharing is not automatic. The United States government must make a request. And it can make a request only if it knows that something abusive may be occurring here. And it may not know that. And now I sort of skirted that issue in the way I set up the problem because I said that Mr. Aziz is being paid for real work. But as you're suggesting, he may not be doing any real work. And it may be that the United States never knows about that, and therefore never knows that IRCO is not the beneficial owner of the dividends.
I'd like to add something from my private practice. It's actually not a problem. Basically, the IRS will come in and say there's a 30% tax. And the burden will be put on the taxpayer to show that there isn't a 30% tax. So the taxpayer, through its law firm, through its accounting firm, has to bring all this information to bear to say that the 30% tax is not applicable, including the consulting agreement. So it gets all the information. If it doesn't get the information, it says there's a 30% tax. So you have.
And they give the information.
Yeah, you get all the information. I mean, that's what I did for a living, basically, to give all the information, to explain to the IRS that the consulting agreement was real, that the Irish actions were real, and all that. And you do all of that before you get to what Professor Fleming is mentioning, competent authority, where if you don't get all the information, you go to Ireland. But law firms, accounting firms police all of this. The IRS gets the information because the burden is on the taxpayer to show that the consulting agreement is good, that there's actually Irishmen that are sweating, putting sand in there. So you spend a lot of time, taxpayers spend a lot of money showing all of that. And if you stonewall the IRS, you lose. You absolutely lose. So the information is there. It's absolutely there. You see how it works? Because of where the burden is.
I'm really concerned about referring to indirect taxation. Because
indirect taxation has nothing to do with an income tax treaty. Keep that in mind. Indirect taxation, VAT and all that. Nothing to do with an income tax.
Nothing to do, but we're starting to think about create models, learn
sure.
with income taxation treaties and such things. So I've been thinking about. I'm starting to read about it, and I'm concerned about effectiveness of these treaties. Would be worth or not?
The burden of the proof is on the taxpayer. That's just pay. No other comments? I can't believe it, but I will try to give a few words to you. You know, I spent most of the time in these last days in the organization of the seminar, so I just prepared a few slides to briefly summarize my experience or my thoughts on it about this. And the purpose of this very, very short presentation is to give some sort of bird's eye view to the students here in Rovigo about European international taxation law, and to Fleming, provide information about how we deal with topics, how we approach to the concept of limitation of benefit clauses, particularly because we don't have that kind of clauses in our treaty with only a few exceptions. And we discussed about this this morning together before this seminar started, and we discovered that as far as we understood, the limitation of benefit clauses that Italy used to implement in the treaties is the former version, or the oldest version of the US used to implement it.
Yes, it's the language in the 1949.
Exactly. So we now our standard, our approach to LOB, limitation of benefit clause, is the one that they used to have at the end of the 40s, but that's not part of the story. So what's the challenging situation about this? So, as I told you, we don't have a specific tradition. Italy doesn't have a tradition or a standard approach about limitation of benefit clause. This means that when you deal with double taxation convention Italy entered into, it's not that frequent to have LOB or articles dealing with this kind of topic. There are exceptions, of course. We are going to debate perhaps one of the most remarkable exceptions in this respect, but the standard is the other way around. The possible reason of the Italian choice, the possible reasons are on one side lack of knowledge or lack of necessity, perhaps, from this point of view. Never did that. We have a sort of customary approach to this. We never felt the need for a LOB clause, and that's probably one of the reasons why we never implemented that in our treaties. Another point is perhaps the lack of necessity, particularly in the latest years. Italian courts have implemented a very aggressive approach toward tax-sparing scheme or abusive schemes or to the substance over form. In the national context and in a cross-border context. So another point against or in favor of the non-necessity of the limitation of benefit clause is that perhaps the national provisions are enough to combat, to tackle most of these situations. And as far as I know, even in the United States, you are implementing very remarkable amendment in your Internal Revenue Code or something like that, because of the amount of reform is trying to perhaps put black on white, a substance over full approach. Is it something like that? So I was wondering whether your unilateral provision from now on could be enough to fight against most of these.
No, I think it's clear that under U.S. substance over form law, our conclusion would be this structure is loaded with substance. You've got real manufacturing activity, you've got real sales activity, and the new provision of the Internal Revenue Code, which says that in general that a tax benefit will not be allowed if it is the product of a transaction that lacks something called economic substance, would have really no impact. At least that's what we think. And we're still waiting on the Treasury Department to issue regulations
about that.
But treaty shopping was not really part of the discussion. The problem that produced this new legislation, and so I think most American tax lawyers would say no problem with substance over form here.
I have no idea about that, but since I read about this, usually when perhaps that's overarching principle to passing also this kind of topic, because in Italy, we have something similar to that. But the judge may perhaps like the bonus rule or very aggressive approach of our courts. I think there will be a few presentations in the afternoon dealing with this issue, with feature of our system. And I think that, it's my personal view, and I think that if we follow that doctrine, if we follow that approach, probably some, if not all, of these schemes fall into the kind of approach, but that's very personal. The second one. The third point, as I told you, the third point is, or the fourth actually, in the slide, is the exception. I'm pretty confident, I'm pretty sure that there are a number of exceptions in the double taxation convention Italy entered into, but the most important one, the latest they stumbled into a few weeks ago, is the one we have with Kazakhstan, which is not that far away from us. Yeah, geographically speaking, it's very far away, but if we think about the business, investment, the flow of income generated from Italy to there and vice versa, then we have a number of Italian companies investing there, not only in the mutual sector, like the Italian state-controlled companies, the Belgian, but also real estate companies, and a number of other Italian multinational investing massively in Kazakhstan and doing business there, and asking for protection of the double taxation convention and the flow of the outbound flow of dividends from Kazakhstan. And there we have Article 29. This is a copy and paste slide taken from the double taxation convention that we Italians have with that republic. And I'm not going to read through it, but you can. And my opinion is that it's very, I don't know how to say that. It's an article, it's a complicated article, but basically saying that we have to look at the substance, at the purpose, go beyond the legal structure the party chosen to develop their business. We have to look at the core decision, we have to look at the core of the business and to take the tax decision accordingly to that. Some sort, that's not, I understand that this is not entirely accurate as an answer, but it's a sort of substance over form approach in dealing with this kind of issue. But as I told you, my opinion was also that as if we look about some of the cases decided by our Supreme Court to recently, it could be argued that the kind of problem Article 29 deals with are also, as I told you before, covered by this new approach. But nonetheless, having a provision like that carved into a treaty, part of the law, rather statutory law, rather than judge-made law, is better for taxpayers and for investors, because of course, you can decide to plan your business with a more detailed, accurate, and stable provision, obviously. So even if the outcome is the same, to deal with statutory law is, in my opinion, better than deal with case law, at least in the civil country. In the United States, it's the other way around, but that's another story. Unfortunately, we don't have enough time now to deal with that. And that's why even this presentation and this slide is very personal, perhaps somehow provocative, but the idea that I had when I started reading LOB provision from an Italian perspective of the merger, but if we look at that with Italian eyes, then I could argue that, well, all in all, the LOB made in Italy is quite similar for the purpose, for the structure, for the goal, for the issues dealing with the beneficial ownership. I mean, perhaps Italy was not in the position to develop further that concept. That's why I asked you whether the beneficial ownership concept was introduced with some pressure from the United States. Because in this way, if this is true, this is correct, and we could argue that there is a link between different concepts, between different tools that are used to deal with the same problem, treaty shopping, treaty reviews, etc., etc., etc. And that's the theory I want to deal with. Then just for you and for the students that are not familiar with taxation, that the few cases that are perhaps well known and from the other side of the classroom, from the students who are doing a PhD in taxation or got the LLM, one of these cases is not a case by a court, but is a decision by the Ministry of Finance, what we call a resolution. This is an answer provided by the Ministry to an issue or problem brought up by local office. The problem is that in this case, the Ministry had to deal with a license pooling contract. I mean, the story was more or less like this. There were 3 companies incorporated under Canadian law, Indian law, and Taiwan, perhaps. I don't remember the flag, but I'm pretty sure it's Taiwan. 3 software companies. All the 3 developed the software for computer dealing with, I don't remember what, that's not important. Then what happened, everyone, A, B, and C, where the owner of the intellectual property, of the copyright of intellectual property, call it as you like, with respect of that software, and they decided to invest or to deal or to license, more precisely, their intellectual property using only one company in the United States. The point was that, I don't remember the story technically speaking, but these 3 softwares, software computer, could be somehow assembled together in order to provide a unitary application for something. And the duty of the American company incorporated in the United States and participated by A, B, and C was to deal with customers all around the world. That is, A, B, and C entered into a license contract with D, and D, on his point, entered into sub-license contracts with E, F, and many other companies. Now the problem was that E company or F company, particularly F company incorporated in Italy, had to pay royalties to company D resident in the United States. Royalties that actually fall into the double taxation convention with the United States, and one could qualify for a reduced withholding tax. That is, for the non-tax law students, once the company F pays the royalties to the company, well, it has to apply a withholding tax with a higher rate if the double taxation convention is not present, with a lower withholding tax if the double taxation convention occurs, is applicable. Now the question is, in this example, the question is very simple. Is company D the beneficial owner of the royalty? Is the actual payee of this flow of income, because it's a matter of fact, it's part of his income, or not? Under formal perspective, yes it is, because it's company D entering the contract, the sub-license contract, brings the signature of the CEO or something like that of company D, I don't remember. So if we look at the scheme with a very formal approach, well, we could say, well, that's not a problem. Company D is the beneficial owner, and therefore company D qualifies for a discounted, reduced, or no withholding tax. The surprise effect, I don't know what could be the answer to this question if the revenue service were in the shoes of the Italian revenue service or dealing with company F. But the point is that, in the point of view of the Italian revenue service, the American company is not the beneficial owner. It is the American company does not qualify for a reduction in the withholding tax, because, as a matter of fact, they say, first of all, because of two factors, basically speaking. The first factor is that the American company is not the original owner of that IP, of that intellectual property. The software does not belong to the American. The software does belong to the Canadians, to the Indians and to the other. That's the first point that took our ministry, our revenue service to that direction. The second point is that payment. An American company was paid as a percentage of the profits generated in that way. In other words, the license agreement between Canadians and Americans sound like, say the Canadians say, look, Americans, you can try and sell our software, whatever the profits shall be, 10% shall belong to you, shall be yours. And even this feature of the contract the parties entered into pushed our ministry to argue that the Americans are not beneficial owners because to a certain extent they don't take the typical risk of business. I don't know whether this conclusion is accurate from your point of view. I cut a number of corners to get the answer because the time is this, but this is the way in which our ministry, our revenue service sometimes deal with this. That's why I figure out the LOB are covered by our code. Another case, I got out of two cases, but we can skip this, which is not really important from our point of view. The other case is very recent and will be debated also, will be commented also by other students and our researchers in the afternoon, so I will be very brief on this point as well, just try and describe the facts. And then the other students and the other researchers in the afternoon will go and the details. It's a very recent, this is the case, it's not a decision by our revenue service, it's a Texas case, and it involves a company present in Italy, company B in this case, which is, as far as I got, part of the Fiat group. I try to summarize the de facto situation. As a matter of fact, Texas is not only a company, but it's two companies, one controlling the other. Like this, so we have two employment company. It's not accurate. This is how the system works. The first one, on the left side of the slide, is the holding company, owning trademarks, technologies, intangibles, whatever. The second one, on the bottom right corner, the actual business. That's the story. That's the story until I think 2006 or so. Then the tax restructured the group in a very complicated way, and in this way actually. Well, first of all, they incorporated a number of companies. The last arrow at the top of my slide, colored in gray, is not represented in the case as my personal consideration, so please disregard it. But all the other arrows are accurate as a part of the story. This is a story as it is. Texas SRO, the company on the bottom right side of the slide is still in Italy because the factory is still there. They still keep on manufacturing goods for the Fiat vehicles. And I hope, and we all hope they're going to stay there for a long time. But that's another story. They incorporated the company in Luxembourg at the center of the slide, which is the most important one in this case, and they attributed, they gave to the company incorporated in Luxembourg all the intangible properties, including trademarks, technologies, whatever, and they entered into a license contract. The point is that the Italian company started paying royalties to the company incorporated in Luxembourg and asking for the company in Luxembourg asking for the reduced standard royalties. The point in question, even in this case, is simple. Texas Lux is the beneficial owner in this tax planning scheme, or it is not. These are the circumstances of the case, and other students this afternoon shall go into detail better than me. And for what concerns the burden of the proof, as Andrea Carinci and Mr. Bonanno said before, the burden of proof in Italy is the same as in the United States. Is the taxpayer who has to go through disclosure about that. And the facts that had to be considered in this case are that, first of all, the trademark was licensed for free to the Luxembourg company, which was a real serious mistake in this case. The company in Luxembourg is fully controlled by non-resident company, particularly one of them was incorporated in Rovigo, as far as I remember, and that's another evidence, another factor that pushed our court to reason in that way. And then third point, the tax and balance sheet revealed that actually the core business of the company incorporated last year was dealing only with intellectual property. So as you see,
was this a decision under the Italian general anti-avoidance rule, or was it based on the beneficial owner?
On the beneficial owner, that's another very important factor. The court didn't feel the necessity to use that sort of judgment GAAR and say, well, we have a concept which is the concept of beneficial owner. I will just skip some slides and go to the last one. What is a beneficial owner? Let's try and say that you are not a beneficial owner when you are fully controlled by another company. You are never a beneficial owner when your business is only like that, even Ph.D. and so on. So a very recent and at the same time aggressive approach on this point which
yeah, much more aggressive than the U.S.
Yes, the definition in the U.S., we have a concept of the ultimate beneficial owner as well. The whole beneficial ownership concept is very nebulous. Ultimate beneficial owner is very tough.
Perhaps there was misunderstanding of this perspective, the owner, beneficial owner, ultimate beneficial owner. But
there's a very little case law in the U.S. on it. What little there is indicates that if you have some kind of spread between the licensing agreements so that the intermediary company does earn a profit.
Yes, okay, so very, very quick, but we are still 7 more or less. Are there comments on? I understood that my very, very short presentation was very technical and it should be quite boring for those of you who don't come from a tax law, Ph.D. or whatever, but are there questions about this? Or in particular, I was interested in the feedback by those of you who have a special background, particular background on civil law, contract, etc., to have some opinions about how we deal with this kind of contract. We from a civil law perspective, we could say that the contracts the party enter into are valid. The Italian word is inefficaci, which is not without deprived of any effect, but they are still valid under civil law or commercial law. Considering the revenue service as a third party in the contract the party is entered into. Questions from the side?
We're wondering about the fact that the company has to apply the convention and not directly for the dividends or royalties, which were probably more simple to apply.
Yeah, probably. Well, let me check about. Yeah, the control was like that. Yeah, they were.
Should they apply the directive?
Because of the it wouldn't be the same anyway, because the beneficial owner concept is also applicable in the directive. So
there is another loose clause. You don't have to ask for the application. It doesn't.
So I think that the feedback was the same as the others. You can see the passage in schools by the so you can join the text in the European law, and Professor Greggi argued that it could have been Brown in this case also not to ask for the double decision direction, but also to ask for the treaty for the directive to be applied. In this case, it can be covered, protected by the directive. Almost that beneficial ownership has moved for double decision direction European law as well. So when you ask for the directive, you must be able to demonstrate
the same for instance for Roy.
Okay, questions concerning Professor Fleming's presentation and these few words I told you, I think that according to the program that we have, we can stop here, have our midday break, and begin again at 2:40 this afternoon. We have some time to enjoy seeing. Oh well, there are no programs for lunch because the budget that we have here in Rovigo, unfortunately, doesn't allow us to provide lunch to all of you. But I'm so sorry for that. But we are very serious about the invitation, but our guests. For those of you who are not